So if the government of Saskatchewan can go ahead, and I'm not sure if it's Mr. McAdam or Morris.
Good morning. My name is Mike Morris, and I'm the Director of Litigation for the Civil Law Branch of Saskatchewan's Ministry of Justice. I'm appearing with my colleague, Mitch McAdam, who is the Director of the Ministry's Constitutional Law Branch. The Government of Saskatchewan has been granted full standing before the Commission and intends to participate in both the evidentiary phase and the policy phase of the proceedings. February 14th was a very significant day from the Government of Saskatchewan's perspective. On the morning of February 14th, a First Minister's call was held. The phone call was chaired by the Prime Minister. That phone call was the first time the federal government told the Government of Saskatchewan that it was considering invoking the Emergencies Act and declaring a public order emergency. The Government of Saskatchewan indicated that it did not want the emergency declaration applying within the province, and other provincial governments did the same. Later that day, the federal government proclaimed a public order emergency. It was not geographically limited, as requested by Saskatchewan and other provinces, and as we know, it remained in effect until February 23rd. For its part, the Government of Saskatchewan is primarily interested in 4 areas which will be explored in this inquiry. The first area is whether there were reasonable grounds to believe that circumstances amounting to a public order emergency existed on February 14th. The second area concerns whether the consultation requirement under Section 25 of the Act was met. Saskatchewan's position is that the federal government had already determined that a nationwide emergency would be declared before the First Minister's call on February 14th. The call was not so much about consulting as it was about telling. The third area concerns whether the emergency measures were overbroad. The financial measures, for example, imposed broad responsibilities on financial institutions with little guidance, and they created offenses for not complying with those new responsibilities. The final area concerns to what extent Saskatchewan residents were impacted by the emergency measures. The government is concerned that residents' rights may have been unnecessarily infringed by these measures. The government looks forward to participating in the Commission and assisting the Commission in fulfilling its mandate. Thank you.
Thank you very much. Next is the Government of Alberta. Again, I believe they were supposed to be online. Here they are.
Yeah.
And I'm not sure if that's who's speaking, but I'm sure you'll introduce yourself. Go ahead.
Good morning. My name is Mandy England, and I'm here with my co-lead counsel, Stephanie Bowes. We are lawyers from the Legal Services Division of Alberta Justice and Solicitor General, and we represent the Government of Alberta together with our colleagues, Hannah Laura Yamamoto, Peter Buys, and Shahir Minai, who will also be attending as counsel during these hearings. The Government of Alberta applied for standing as a party before this inquiry for 2 main reasons. First, Alberta believes it is important to share with Canadians the facts about how Alberta was able to effectively deal with the international border blockade in Coutts, Alberta, prior to the invocation of the Federal Emergencies Act. Alberta's evidence will show that the existing law enforcement tools that were already in place were completely sufficient, and they were successfully used to peacefully restore the flow of traffic at the Coutts border crossing and to disperse the protest to a legal protest site. None of the powers that were created under the Federal Emergencies Act were necessary, nor were any of them used in Alberta to resolve the Coutts blockade. Alberta is also here to participate in the process of holding the federal government accountable for its decision to invoke the Emergencies Act. Alberta has many questions about how and when that decision was reached. A decision that was made despite the objections that Alberta and other provinces expressed during a phone call placed to the First Ministers on the morning of February 14th, 2022, just hours prior to the announcement that the Federal Emergencies Act would be invoked. Since the federal government proclaimed that a public order emergency existed throughout Canada, the Act requires that all of the provinces must be consulted before it can be invoked in that manner. Yet, Alberta's views were only asked for after the decision was apparently made, and they were basically ignored. The impact of these measures on the rights of Albertans is of great concern to the government of Alberta. Alberta is here to find answers for its citizens and for all Canadians. We thank the Commissioner for this opportunity to appear as a party, and we look forward to working with the Commission in the weeks to come.
Thank you, Ms. England.